Hey folks, this is Boren, criminal defense attorney and former felony prosecutor. I want to talk to you today about how a broken taillight can land you in prison for 20 years or more. Yeah, it seems kind of outrageous, doesn't it? Let's say you're just going down the highway and you don't know it, but you've got a taillight that's out. Now, it just so happens that your vehicle has a Colorado plate on it and you're traveling through Texas. Well, police look for that. Now, do you think they stop everybody with a broken taillight? No, they don't. But it piques their interest that it's a Colorado plate or a Florida plate, some suspicious place that's known for drug trafficking. So they stop you. Well, is that a proper stop? Yes, because your taillight's out. Now, that doesn't mean they're going to, of course, write in the report that they were suspicious that you had a Florida plate or a Colorado plate. That's not gonna land in the police report. They're just gonna say you had a broken taillight. So that's gonna make the stop proper. That's when the detention starts and the time clock starts ticking. That's when you need to turn on your video app on your phone when you get stopped and the games begin. The officer may want to search your car by consent. Hey, can I search your car? And you certainly can turn down the search. You don't have to allow them to search. A lot of people are tempted to let them go ahead and search because they want to look like they're not guilty of anything and they want to prove that to the officer. You do not have to do this. Now, to hold you any longer than just the time it would take to write you a citation for the traffic offense, the officer's going to be able to speak or articulate some reason he's wanting to detain you beyond that time. Now, that's why if you're running your video app on your phone, that when you ask them that question, if they can't say or don't say, that's going to help you if you ever have to challenge this. So, of course, don't cut and run. If you're in a vehicle, that's a felony in and of itself. Now, sometimes officers will say, well, I've got probable cause to search because I smelled marijuana. I have extreme doubts if this is the case much of the time, because it's in almost every police report regarding a search of a vehicle alongside the road. I just know people that are holding that they aren't smoking and they've got everything wrapped up tight and hermetically sealed, and it's not going to be able to be detected. Now, here's the thing. If you're stopped for even what's a Class C misdemeanor, the lowest level crime in Texas, it's only punishable by a $500 fine, up to a $500 fine, and no jail time. The officer can still arrest you. Yes, you can be arrested for a Class C misdemeanor in Texas. But the problem is if they arrest you, they can search the vehicle, what's called incident to arrest. Now, here's where it gets into the weeds a little bit. They're going to have to follow their procedures that are laid out by their law enforcement agency, whether it's the city police or the Department of Public Safety or county. Often, they just dive right in and get to searching on the side of the road. And that well could be a violation of their policies. Also, there could be an issue of just detaining you too long. That could allow the judge to hang his hat on suppressing this evidence. Now, if they detain you too long, it is a matter of judgment, really, and that's up to the judge to determine. There are some cases, but there's no per se time. If you're waiting for a drug dog to come and sniff and if the officer hasn't articulated very good reasons or any as to why you're being held, and you've got that on video or audio, even if the officer doesn't answer you, that's going to help you. Now, best practices, of course, this is an absolute no-brainer, is don't be hauling around drugs or illegal substances in your vehicle. You're really vulnerable to being discovered and getting a major sentence off a simple traffic offense. I hope this was helpful.